Hey everyone, thank you for watching. This is Jonathan Ratchik of Kramer, Dunleavy Ratchik. We are a boutique personal injury law firm here in New York City. And what we do is we help people who have been injured due to the negligence and wrongdoing of others. And we do that by getting the monetary compensation for their pain and suffering, a loss of enjoyment of life, and economic loss. So today I'd like to talk about an issue that oftentimes comes up here in New York City and throughout New York State, and that is dangerous stairs. Okay, stair-related falls. So in any city like New York City, stairs are a part of everyday life. Okay, we encounter them when we go in and out of our apartment buildings, come to and from work, go to restaurants, movie theaters, Broadway shows, brownstones, to school, anywhere and everywhere. And most of the time when we're going up and down them, you don't even think twice about it, right? It's such a routine road occurrence. But sometimes when a staircase is poorly maintained, or maybe sometimes even improperly designed, maybe it's not well lit, maybe it's wet, maybe the handrail is loose, it can cause someone to be involved in a serious injury and to get seriously hurt. So in this video, I'd like to talk about the types of cases that relate to dangerous stairs and staircases, okay? And the duties that owners and management companies have, and the types of damages that someone can recover in a lawsuit arising out of a fall on a dangerous stair or staircase, okay? So let's start with some of the most basic types of accidents. And those are oftentimes caused by when there's a broken, loose, or maybe an irregular step, right? And so someone's walking down a staircase, step on a loose tread or loose riser, and causes them to lose their balance and fall, okay? Maybe there's not a handrail there, or maybe the handrail is loose. Maybe there's inadequate lighting on the staircase, okay? And they're also heavily involved in slip and fall cases, right? So staircases, if they're supposed to be kept dry, there's in the better ones there might be treads to help people keep their balance. But if a staircase or stairway becomes wet, whether it's from rain or snow or dirt, debris, whatever it might be, that can cause someone to slip and fall, okay? And again, these can result in very serious life-altering injuries, okay? And oftentimes these incidents, they don't occur out of nowhere. They're oftentimes there are prior complaints, maintenance requests that relate to staircases, failures to inspect it or to follow up on inspections, okay? And which begs the question that these are oftentimes incidents which, if someone was exercising reasonable care under the circumstances, the incident would have never occurred in the first place. So what's the duty of a property owner when it comes to a fall on a dangerous or on a staircase in general, right? We won't even say that it's dangerous. So generally speaking, like any premises liability case, an owner has a non-delegable duty to maintain their premises, including the stairway or staircase, in a reasonably safe condition, okay? And that entails everything that you might think of as it relates to reasonably safe. What should a reasonably prudent owner do? That includes inspecting the stairway, maintaining it, cleaning it, repairing broken or uneven steps, okay? Keeping the handrails in good condition, making sure the light bulbs are illuminated, staying compliant with the building and the housing codes as it relates to staircases. And these cases oftentimes come down to notice, right? And not just these cases, really any premises liability case oftentimes hinges on the issue of notice. And the question is whether or not the owner or even its management company either knew about the condition, right? Or, okay, so if it knew about the condition and failed to take reasonable measures to correct it or clean it up, that could give rise to legal duty and responsibility for any harm resulting from a breach of that duty, okay? There's also the issue of sometimes maybe they don't have actual notice, but maybe they have what we call constructive notice. That's where a condition on a staircase has existed for a long enough period of time, and it has to be readily apparent, right? It can't be hidden, it should be apparent and visible to the senses. So maybe that condition existed for a long enough period of time so that the owner or management company, if they're exercising reasonable care, should have discovered it and corrected it, okay? It's when these dangerous conditions about which they have notice get ignored or they're allowed to persist, that's when liability follows, okay? And again, that holds true for an owner. It also holds true for their management company, even though the management company might not have its own separate independent liability as it relates to someone hurt on a staircase because the owner has a non-delegable duty. The management company is arguably the agent of the owner. And so any negligence on the part of the management company, in my mind, is attributable and flows through the management company to the owner, right? That's what they mean by non-delegable, right? The owner can't say, like, I gave it to the management company. No, it's the buck stops with you, owner, right? You are the one responsible for the maintenance and the safety, the maintenance of the staircase and the safety of the persons using the staircase. And if you hire a management company to perform maintenance or to keep the stairway clean, safe, dry, whatever it might be, any negligence on their part is arguably going to flow through them and be attributable to you. So you don't get away from liability or skirt liability by hiring a management company. And so oftentimes these types of cases are going to require proof of notice. Again, I can't emphasize that enough. These cases all hinge on notice, demonstrating that the owner or its management company, whomever, had either knew or should have known about the dangerous stairway condition that caused or contributed to the incident, okay? And maybe that means maybe there are maintenance or inspection records, photographs of the staircase, maybe there's surveillance footage, building code violations, you name it. This is all evidence that is amassed in trying to prove and demonstrate that an owner had notice of a dangerous condition in their building, okay? And so, and it's why in these types of cases, it's so important that if someone is hurt on a staircase, okay, whether it's a trip and fall due to a dangerous condition on the staircase itself, or perhaps maybe it's a transitory condition, or maybe the staircase was wet, maybe it was, or debris or something had spilled on the staircase, it's imperative to take steps necessary to preserve that evidence. And oftentimes the best evidence is sometimes the most simple, right? Photographs. There's that old expression, a photograph is worth 1,000 words. In a premises liability case, and especially in a dangerous staircase case, it's important to have photographs to identify the exact dangerous condition which the injured party is claiming caused their fall, okay? Especially on these transitory type conditions where the staircase is wet, whether it's from water or oil or whatever it might be, that type of evidence can't be recreated. So it's really important that it be preserved, if at all possible, as soon as possible, because that evidence, once it's gone forever, and it can't be recreated, okay? But photographs are really important. Yeah, again, maintenance and inspection records. If there's a dangerous condition on the staircase, maybe as it relates to the riser or the tread or they're worn away, you want to get in there sooner rather than later, because if the owner or management company gets wind of someone's injury on a staircase, guess what? If they're at all concerned about their liability, they're going to hire someone to fix it. And then once it's fixed, all of a sudden the evidence that you needed to prove your case is gone. You can still have your own testimony to describe what the condition looked like and this, that, and the other, but there's really, at the end of the day, no substitute for photographic or video evidence, or even better, getting an expert in there to perform an expert inspection or evaluation of the staircase. That's invaluable evidence, which is going to disappear as time goes by, okay? So in the event that someone has a fall on a dangerous stair or staircase, the damages recoverable are going to be the same as in any other type of personal injury lawsuit, right? So they're going to be able to recover damages for their pain and suffering that's past and future. And that includes the subset that we refer to as a loss of enjoyment of life. If you think about the things that you enjoy doing on a day-to-day basis, whether it's chores, activities, whatever it might be, to the extent that your injuries impact negatively your enjoyment of life, okay? Maybe you can't play basketball the way you used to. Maybe you can't dance or bowl, whatever it might be, take walks with your spouse, whatever it might be, that category of damage is compensable in New York. There's also past and future medical expenses, whether that's for hospitals, doctors, physical therapy, medications, and also past and future economic loss. Okay, that can be lost earnings, past and future, or maybe lost earning capacity, or maybe you had to take a different job because you couldn't perform your job duties the same way that you used to because of your injury. But all these damages, they are all compensable in a premises liability lawsuit caused by a dangerous stair or staircase, okay? And again, I want to emphasize this. I really can't emphasize this enough, how important it is to preserve evidence as it relates to a fall on a dangerous stair or staircase, okay? Again, broken steps get repaired, water gets cleaned up, burned out lights in the stairwell, they get replaced, maybe surveillance footage gets overwritten. But the more time that goes by, the harder it gets to prove that the owner had notice and knowledge of the condition that caused the accident in the first place. Okay. And why it's always important to seek legal guidance sooner rather than later. Okay. All personal injury attorneys, we all work on a contingency fee basis. None of them charge for an initial consultation. And it's always important to speak to someone knowledgeable sooner rather than later, so that the necessary steps can be taken to preserve evidence, which, again, as time goes by, that evidence is going to disappear. And that case is going to be a lot harder to prove if and ever when you take it to trial. Okay. Thank you again for watching. If you found this video helpful, please subscribe and click on the notification bell so you don't miss another one. And again, if there's a topic that you'd like me to discuss, I certainly encourage you to leave a comment at the bottom. And lastly, if you know someone, either you or someone who has been injured due to negligently maintained stair or staircase, certainly reach out to a qualified attorney sooner rather than later so that your claim can be properly investigated and the evidence preserved. Again, thank you for watching. Jonathan Ratchik from Kramer, Dunleavy Ratchik. Experience you expect, commitment you deserve.